Welcome back to Core and Civics, everyone. My name is Brian. I'm a high school social studies teacher who's created this channel to hopefully better most of our civic understanding of the world and current events. It's not just a course that you should take one semester in high school, but something you should always be involved with and trying to educate yourself on. Today is going to be the first and hopefully an ever-growing series about Supreme Court decisions, just summaries of them to help us better understand and digest those really long opinions that these judges write that are not in the most approachable or, layman's terms for us to understand as the average American. Today's case is going to be Trump v. United States, the one case this past term that had the most public attention, I would say. This is a presidential immunity case. Essentially, the question here is being asked by the Trump, former Trump attorneys and himself, whether presidents are above the law or not. So I'll give you some background of the case. We'll go into the arguments of either side, the decisions, and then the response by the country and legal experts as well to the decision. So let's just jump in. So the background of this case. Trump is indicted in August of 2023 by Special Prosecutor Jack Smith. He is investigating Trump's involvement in the January 6th attack on the Capitol and whether he should be criminally responsible for this. And being indicted, he believes that he should be held criminally responsible for at least parts of it. And so the Trump team makes two claims in response to this to try to dismiss the case, to get it, essentially remove the case entirely. The two arguments they make are, one, that he, Trump, cannot be prosecuted for his official acts as president. They go on to describe, and we'll talk about here in a second, what official acts are, but essentially saying that his actions on January 6th were part of his official acts as president, and therefore he shouldn't be held criminally responsible. The second claim is that even if we're wrong about one, and that he could be held criminally responsible, he should not be able to be tried at all because he was never formally removed by Congress. The second argument is essentially saying that he was impeached twice, yes, but he was not found guilty or convicted by the Senate and never removed from Congress itself. So therefore, you cannot punish him or criminally try him at all. So how does this case reach the Supreme Court? The timeline is initially when this case is brought, the U.S. District Court Judge Tanya Chutkan, she sets the date for March 4th of 2024, that's when the arguments will be presented from either side. However, because the Trump team has made this attempt to dismiss this case because they think Trump is immune, she freezes that date and rules on that instead. So she takes some time and decides that no, Trump is not immune from criminal prosecution, and therefore we will go forward with this case. Again, the Trump team then appeals. This time they try to get all the way directly to the Supreme Court to try to circumvent or try to get around the D.C. Circuit Court from ruling, but the Supreme Court denies them. The reason that they tried to do this is because the Supreme Court they know is going to be more favorable to them. If you did not watch my first video on the Supreme Court or my just overview of that, I'll link that above. But that goes into each of the 9 justices and understanding maybe why they'd be favorable to them. 6 of the 9 are conservative, and 3 of them were actually appointed by Trump himself. So they understand that probably those individuals on the Supreme Court are more likely to rule in their favor. But the Supreme Court does deny them and says, no, you have to go through the formal process. You have to go through the D.C. Circuit first, and so they do so. So the D.C. Circuit then hears their arguments, and they decide on February 6th of 2024 that no, we agree with the lower court's ruling, the district court and Judge Chutkan's ruling, that you do not have immunity in this case, and therefore Prosecutor Jack Smith can then bring his case to the court. They appeal one last time. They get one last chance to appeal, and they appeal to the Supreme Court, and the Supreme Court does grant cert and does allow them to have make their appeal to the court itself. And they hold those oral arguments on April 25th of 2024, and that is where we get the following arguments. So the arguments for Trump, we'll start with his side. Trump's side makes the argument, the same two that I already mentioned. One, that presidents are immune from official acts that they make while in office. And so everything that Trump did during January 6th were part of his official acts, and in the aftermath after were a part of his official acts as president. The second is the same thing I already mentioned, that he says that presidents cannot be tried at all unless they're removed by Congress. And then the third is that Trump's actions were all official. So one of these acts that was really intensely scrutinized in this case was Trump had called or sent a letter, I believe, to the Attorney General, acting Attorney General of the Justice Department, and said, hey, can you start investigating this election fraud that has occurred in the election of 2020? And the Attorney General responded to the Trump administration and said, we're not going to do that. There is no evidence of election fraud, and so therefore we're not going to waste our resources, time, and money to investigate this claim. Trump then threatens to remove the acting Attorney General, to fire him and to replace him because he's not doing his bidding. But Trump's attorneys are saying that's fine because calling an Attorney General, contacting the Attorney General is a part of a president's official acts. The United States government, who's on the other side of this case, is saying Trump nor any president in history should be uniformly above the law, that they should always be held criminally responsible for some things, and that in this case, Trump's actions that are being prosecuted, he is, criminally liable for. The second argument is that presidents do have some immunity. So the U.S. does concede, the government does concede that, yes, presidents do have some immunity, but it is limited to the powers that are explicitly vested in the office holder of the president in the Constitution. Everything else is not, right? So this could be like the commander-in-chief power that presidents have that's explicitly listed in the Constitution. So being the commander of our Army and Navy, that's really, a core power that's listed in the Constitution that they'd be criminally liable if they're acting in those, or immune if they're acting in one of those roles. And then they really hit home the third point. This is where they focus most of their arguments, is that the ramifications that if you say that a president is immune for official acts could be devastating for the country in the future. That presidents could then abuse their power and do things in office that are part of their official acts but solely benefit themselves or their party or their ideology, and target or marginalize people and hurt the country quite substantially as a result. And so they really try to hit home to the Supreme Court how scary it could be if they side with Trump. And so these cases are submitted in April. The Supreme Court then convenes for a couple months. They release this opinion in June about what they decide. And so let's go into those decisions. So the majority opinion, which is what matters, it is the binding precedent, it is the rule of the land, is a 6-3 decision for the Trump side of this case. And so I've actually screenshotted a picture here from a lovely article written by the person at Brookings, a University of Michigan legal expert, about this case, and this is like the outcome of it. I'll link that article. It's really lengthy, but it's a really good article about this case and like the opinion and how some of the feedback and criticism of it. But this is the synopsis of the key parts of this. There is more that goes into the majority opinion, but I just want to hit home on this. So the first thing is that the majority opinion does say that former presidents can be criminally prosecuted for unofficial acts, so things that are not part of their official duties. But again, they don't specify what those unofficial acts are or what official acts are. But they do go into the second part, which is the constitutional scheme for separation of powers requires that former presidents have some immunity for criminal prosecution for acts taken while in office. And so I'm not going to read this whole thing to you, but essentially saying that when it comes to Article 2 powers in the Constitution, there is absolute immunity given to the president, which means they have no criminal responsibility or liability at all in that. And that they say that when deciding whether an act is official or unofficial, so to determine whether it should be criminally liable or not, courts cannot inquire about a president's motives. So let's say a president decides to use their military power, their commander-in-chief power, to benefit themselves in one way or another. Courts cannot be like, okay, why does the president do that, right? And if they're doing that for a slimy reason, that doesn't matter. The case is more like the majority opinion is saying you can only focus on the actual action. So if the action is unofficial or official, that's all that matters. It doesn't matter why they're doing it or what reason they're trying to, commit this action or conduct. It just matters what the actual action is. And the last thing says courts may not deem an action unofficial merely because it allegedly violates a generally applicable law, which is a weird thing to say. So essentially what that means is that a court can't say this action is unofficial because it's actually violating law. So let's say that the Trump uses the military to put on a hit job for a political rival and kills and assassinates their political rival, right? That's murder. That's, soliciting murder. That is a crime that applies to all of us. The court is saying here that just because that's a crime doesn't make it unofficial. right? Doesn't mean that they're criminally responsible. So they're essentially trying to deviate between what a crime is and what official slash unofficial act are. So just because something is a crime does not mean it is criminally liable for the president. So it's giving them a pretty wide, a broad immunity to these presidents. The opinion was written by Chief Justice John Roberts, but it was signed on by all 6 conservatives, so the other 5 being Kavanaugh, Barrett, Alito, Gorsuch, and Thomas. So the 3 are the 3 more liberal judges. So let's break down the dissenting opinion here. So I just screenshotted screenshots from this opinion to give you a good overview. I'm not going to read the whole thing to you, but hopefully you can pause and read this. But I do want to read a couple stanzas to you. I'll read the right side. So the left side I think is really interesting, and that Sotomayor, who writes this opinion, is pretty witty and pretty snarky with her comment in the left one. And she says, if you can see my cursor, this official act's immunity has no firm grounding in constitutional text, history, or precedent. She's quoting a decision that you may recognize, Dobbs v. Jackson Women's Health Organization. This is the case that overruled Roe v. Wade and was written by Justice Alito, one of her colleagues, in which he says that abortion, there is no firm grounding in constitutional text, history, or precedent for the right to an abortion. And so she is basically saying, okay, I'm going to use your own words against you in this text, and that there is no firm grounding in constitutional text, history, or precedent when it comes to presidential immunity. There's no constitutional land or ground for that. And then this right hand side here, she argues the ramifications that these decisions can have. And so I'm going to start here. It says the president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold on to power, immune. Takes a bribe in exchange for a pardon, immune. Immune, immune, immune. Let the president violate the law, let him exploit the trappings of his office for personal gain, let him use his official power for evil ends, because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Extremely critical, writing here by Justice Sotomayor about the majority's opinion, and saying that this could have really damning effects long-term on the office of president and who holds that power. And she concludes it in this way. She says, never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy, I dissent. An extremely powerful conclusion there, right? Especially the last line. With fear for our democracy, I dissent. Most of the times you see with respect, I dissent, or just I dissent. You rarely see added things on there, but that obviously is showing her power there. So the 3 liberal judges signed onto this and saying that this is very scary. I don't know what the future is going to look like and what we have done as a court today to grant that power or that office such immense power going forward. So how were people reacting? In summary, not great. Legal experts, people generally in the public did not like this response. So the 2 screenshots I have on the left here are set from that same Brookings article. And if you don't know what the Brookings Institute are, they're a nonpartisan research institute about politics and legal decisions that is based in DC. And so in this writing, I'm just going to read the top one. The left one, or the last one, goes into kind of the fundamental issue with the Roberts opinion, the majority. But the top one just says, in thinking about the court's decision, the first and last of these propositions are widely accepted and non-contentious, which were that a president can be charged or criminally responsible for immune acts or unofficial acts in office. And then the last proposition was essentially stating that they could be criminally charged even if they weren't impeached. But the other 6, which I didn't show you a screenshot of all of them, but again, I will link the article, are not generally accepted and are poorly justified if they can be justified at all. Again, a really harsh criticism to basically be there's no justified reason why the majority made this opinion that's grounded in the Constitution. And the right-hand side are some media outlets, the ACLU, The Hill, The Atlantic, all really critical of what this could mean, right? The Supreme Court grants Trump, future presidents, a blank check to break the law. the Supreme Court has some explaining to do in Trump v. United States, and something has gone deeply wrong at the Supreme Court. This has called into the court's legitimacy even more, the dangers of what this decision and some other ones like the Dobbs decision have been, why they've been made and how they've been made, and the lasting impact that they could have on the country or people are really critical of. So definitely not a light, summary in here. Like, this case is not a very easy one in terms of significance, but it is very, very important to understand going forward that, this ruling could have a lot of impacts going forward. Sotomayor makes the argument that we've made a president a king now. And in some ways that's true. It's obviously probably a little hyperbolic, but in some ways that we've definitely granted them a lot more immunity going forward. So if you have any questions over this case, or what do you think about it? Do you think that presidents should be immune from the law? Do you think that this was the right ruling? Or do you think that the majority went a little too far? So just let me know, leave a comment, like and subscribe, and I will continue to do these recaps going forward. Thank you, guys.